All right, hi. I'm John Hayes. I'm a certified bankruptcy specialist in Los Angeles. I also am an adjunct professor of law at the University of West Los Angeles Law School, where I've taught for roughly 30 years. I teach bankruptcy most years and business organizations. I started my bankruptcy class this semester a couple of weeks ago. This is the, spring semester of 2021. We just finished class 3. So the idea behind this video is that I'm going to walk through what we did in class 2. Which is a discussion of some chapter 7 basics and this concept of abuse and bad faith cause those horrible things. The first class we did a general overview, and the second class was abuse. So I'm going to go into quite a bit more detail than I usually do, so that my students, when they start studying towards the end of this semester for the final exam, they can listen to this. But I also think that this video will be very useful to lawyers that are thinking about getting into bankruptcy, what we call dabblers, those lawyers that don't do bankruptcy, but it looks pretty easy and a lot of it's coming. They really should listen to this video. But also, I think most bankruptcy lawyers don't really get a chance to think about the theory, basically, of bankruptcy and, what does bad faith mean? So that's what I'm going to talk about for a while. Courts of appeal and most judges love to, when they're analyzing something, they love to say, well, let's start with the code. Absolutely, I agree with that completely. Bankruptcy, our bankruptcy law was created by Congress. It went into effect in 1979. And, Congress told us who can file bankruptcy. People are a little surprised when I tell them, Congress could dissolve, could say there's no bankruptcy, no federal bankruptcy at least. Congress could say all of it, next week, they could say we're not going to allow Chapter 7 anymore. We're not going to allow a discharge unless you pay a certain percentage of your debts or something. So who can file bankruptcy? Whoever Congress says can file bankruptcy. In the law of 1801, the first bankruptcy code that Congress passed, only traders were allowed to file. People, I've never seen what that means, but I assume it's people who trade goods. Only traders could file bankruptcy. So Congress told us. So who can file bankruptcy? We start with the bankruptcy code, and we start with section 109 of the bankruptcy code. And 109, the title of 109 is who can be a debtor? Who may be a debtor? Right. So 109A says anybody, any person, if they live in the United States or have a business in the United States or have property in the United States, can file bankruptcy. Person is defined in the bankruptcy code as not only a human being, but corporate type entities can file bankruptcy. in the United States. What corporate type entities are can raise issues, you know. I don't think business trusts can, I'm not even sure a trust can file. I don't know if a trust is a person who could file bankruptcy, but anyway, section 109B, as in boy, says that anybody can file Chapter 7, any person can file Chapter 7 with a couple of exceptions. One is railroads can't file Chapter 7. Banks can't file bankruptcy. All right, I took a quick break because I thought I better look up section 109 again to make sure that section 109B deals just with Chapter 7. And it does. So railroads can't file Chapter 7, banks can't file Chapter 7, insurance companies can't file Chapter 7s. Everybody else can. All right, so when people call me, you know, will the judge let me file bankruptcy? Well, I mean, are you a human being? Do you live in this country? Then yes, you can file Chapter 7. What's all this bad faith, you know, abuse, the means test? What is all that? Well, that to get to that, we have to look at section 707 of the Bankruptcy Code. Congress, it's historical, but Congress has created chapters, and you'd be surprised to know, I'm being sarcastic, Chapter 7, the Bankruptcy Code deals with Chapter 7 cases. So we have a code section called 707. And section 707 is called dismissal. So a court can dismiss a Chapter 7 if section 707 is met. All right, so that's most of what I'm going to talk about for the rest of this video. So section 707 has two parts. Section 707A and section 707B. All right, so 707A says a bankruptcy, the court can dismiss a Chapter 7 case for cause. You know, so now we know, you know, all you need is cause. And well, what does that mean? Congress didn't tell us what that means. They did put in 3 examples. They said cause including, but the examples aren't very helpful. If you don't pay the fees, you don't fill out the right forms, or you delay, I don't know how you can delay a chapter, how the debtor could delay a Chapter 7, but in any event, a case can be dismissed by the bankruptcy court for cause. Somebody has to file a motion. The debtor has to get served. The trustee is served. There's a hearing, and the judge looks at the facts and decides whether there's cause or not. 707B is sort of the same thing, but what section 707B says is a case can be dismissed for abuse. Well, what in the world is the difference between cause and abuse? You know, that's what we're going to discuss. All right. But I want to say one more thing about 707B, because it'll factor into what I'm going to talk about also. Section 707B says that this concept of abuse applies only to debtors whose debts are primarily consumer debts. What's a consumer debt? Well, Congress did define that, a debt incurred for personal or household reasons. if your debts, you have this many debts, you know, X thousands, whatever. If more than half of that is debt incurred for personal or household purposes, then if more than half is consumer debt, then 707B applies. At least for now, I don't know whether 707A doesn't apply, but I'll sort of give you a hint about that. It doesn't. The Ninth Circuit Court of Appeals has told us that if the debtor's debts are primarily consumer debts, then 707A doesn't apply cause. All right. So let's go back then to 707A, cause. You know, it's kind of a problem actually. The cause to me is sort of like this concept called bad faith. And I joke with my students, and to the extent my students are listening to this, I'll remind them, I hate bad faith. I hate when people say bad faith. I shudder when judges say bad faith. You know, don't say bad faith on exams that I give you anyway. Unless, I mean, there are times when it depends on whether it's bad faith or not, and I'm going to tell you what I think bad faith is. But bad faith, you know, from my experiences, you know, something that sort of offends your personal sense of fairness. So, you know, we have something like 350 bankruptcy judges in this country. So, you know, if bad faith is something that sort of offends the judge's personal sense of fairness, I mean, that Congress didn't say that that's cause, you know. I've read a lot of cases on this area. I read a case where the debtors hadn't filed taxes in 5 years or 10 years maybe. And the judge said, well, you know, how you want to come to the government now and get a discharge of your debts and you won't even bother to file tax returns? I'm dismissing your case for cause. There was a lady who had a lot of student loans, and she's, I don't know if you can hear my dog barking. She's out in the backyard making sure there's no squirrels. Student loans. This lady had a lot of student loans, and what she was one of these people who keep going to school. You get a degree, now you got to start paying your loans back. So she'd go get another degree. So she had 4 or 5 degrees, I think, and she was in her late 50s. And the court said, you know, that's not very good. You shouldn't be doing that. And I don't think you should be allowed to come and file bankruptcy if you're going to just avoid your student loans forever. That's cause, and therefore the case was dismissed. You know, so you can go from there to, well, what if you're in jail? You know, I have filed bankruptcy for people in jail. What if you're a lawyer that's been disbarred? I've filed for several lawyers who have been disbarred. I mean, what if you're got a drunk driving, you know, or I mean, you can imagine all sorts of horrible people. You know, is that what Congress meant when Congress said a case can be dismissed for cause? That answer to me is clearly not. So let's try to figure out, what does cause mean? All right, so what does cause mean? You know, my view is, and then if you want to call this bad faith, be my guest. although I'm going to talk about a case in a minute that'll distinguish a little bit between cause and bad faith. But what is cause? It's bad faith. My view is anytime a person files bankruptcy, any chapter, for the purpose of doing something other than why bankruptcy was created and why bankruptcy exists. If you're filing bankruptcy for some reason other than to get what Congress decided bankruptcy was created to do, that's bad faith, that's cause. All right, so that raises the question, well, why do we even have bankruptcy? And I can give you a nice clean answer, I think. And what it is bankruptcy was created to make the process of selling the debtor's assets more efficient. So right now, if you don't pay your American Express card, they sue you, they get a judgment, they start grabbing your property. American Express, they can only grab what's exempt, whether you're in bankruptcy or not. But they get a judgment. The first guy to the assets is going to get paid in full, or the full value of the assets that they grab, and whoever comes along second or third or fifth isn't going to get anything. Plus, grabbing some asset could be the reason why the business fails, or if the debtor is a taxi cab driver and the first guy grabs the car, then there's no taxi business anymore. Now nobody's going to get paid. So bankruptcy was invented to stop that, to stop the race to the courthouse. So the idea that why don't we just have one person grab everything that can be grabbed, meaning non-exempt property. Let's have one person grab that. Let's make everybody else wait. The trustee will grab it, sell it, and give the money to all creditors as a group. That's the reason bankruptcy was invented. Any other reason why we have bankruptcy? Well, today it's the discharge. Most people who file Chapter 7 need to wipe out their debts. And it's called the fresh start. Congress said that's a good idea. For whatever reason, you can do that once every 8 years. It's a whole bunch of debts you can't wipe out. But so bankruptcy exists to make the sale of the debtor's assets more efficient and to give the debtor a discharge. If you're filing bankruptcy, if you're filing Chapter 7 for some purpose other than one of those two things, I think there's a great argument that it's a bad faith filing. So what would some of those things be? I saw a couple up in front of the podium once in court, and they were telling the judge that, they intend to pay everybody. No, judge, we're good people. We're going to pay everybody except this one guy, this bad creditor that keeps bugging us all the time. We just want to file bankruptcy on him. They're describing a bad faith case. You don't get bankruptcy. You don't get the discharge just to wipe out somebody you don't like. And if that's what you're trying to do, that's cause to dismiss the case. What's another reason? I get calls all the time. Person's in litigation right now. They say, the judge hates me. I need to get rid of this judge. I'm going to show him who's boss. I'm going to file bankruptcy and do all this in front of the bankruptcy judge. I don't want the state court guy. I want a bankruptcy guy. That's not why bankruptcy was invented. If that's why you're filing, you're probably at cause, I think. What would be another example? we get calls all the time, you know, I need to file bankruptcy. Why? Because I need more time to do this and that and these things I'm trying to do. And, you know, often, obviously, the question of fees comes up and they start telling you, oh, I don't need all that bankruptcy stuff. You know, this is real simple. I just need time. I just need the automatic stay. I don't want to do bankruptcy, but I need the automatic stay so I can keep negotiating. You know, you're not filing to do what the purpose of bankruptcy is. You're brushing up against cause, I think. So that there's two cases in my materials that talk about, help us figure out what bad faith is. And the first one is a case called Padilla, Padilla. If you want, leave a comment. I'm going to post this on YouTube. Leave a comment in YouTube that you want the site for Padilla, and I'll respond. It's a Ninth Circuit case. It's actually right here in Los Angeles. But what we had in Padilla is this guy is running up his credit cards. Obviously, he ran up his credit cards right before he filed. And the case calls it a bust out. This is a credit card bust out. You know, those are horrible people. A guy who's doing a credit card bust out should not be allowed to file bankruptcy. And the bankruptcy judge, very good judge here in Los Angeles, if he listens to this, I can completely see his point. But he dismissed the case and he said there's cause, and the Court of Appeals reversed. And they told us a couple of important things. The motion was brought under Section 707A. So the creditor's trying to prove fraud, cause. And the judge found cause. But what the Court of Appeals told us is this particular debtor's debts were primarily consumer debts. Therefore, it should have been brought under 707B. In that case, it didn't really make much difference, but the rule pretty much is now that if the debtor's debts are primarily consumer debts, 707A is irrelevant. All right, the second thing that Padilla told us, they chided the judge a little bit. Same way I've been sort of doing, you know. I mean, I'm not chiding the judge. I'm just chiding you all, and especially my students. Is the case said, don't talk about bad faith. This is cause. Talk about cause. And it's sort of the same thing, but don't do that. Leave out bad faith. Bad faith is something that smells. You know, cause is, I've said a million times, one person's bad faith is another person's shrewd lawyering. You know, so focus on cause. What Padilla told us is that if the conduct of the debtor is something that the bankruptcy code deals with, then it's not cause. You know, and what they were saying is that the running up your credit cards, intending to not pay them and file bankruptcy, that's fraud. And the bankruptcy code deals with fraud. The bankruptcy code says if the debtor does this and this and this and that's fraud, here's what happens. The debts are not discharged, right? So if the conduct is something that the bankruptcy code resolves, or at least provides a mechanism for resolving. If Congress tells us, look, here's what happens to people who do this particular thing, then that's not cause, which makes sense. You know, if everybody who committed fraud was prevented from filing bankruptcy under 707, you would never get to the fraud part of the bankruptcy code, right? So the second case is a Ninth Circuit case, and the client was mine at one point, but it's called Sherman, in re Sherman. And the Ninth Circuit said really the same thing I've already been saying, is that it can't be bad faith if the bankruptcy code describes how to deal with the conduct that is supposedly bad faith. All right. Not sure I have anything else to say about 707A. If I think of something, I'll bring it up. So let's go to 707B. Abuse. Why they needed to, who knows? But I have to give you a tiny bit of history on abuse. When our bankruptcy code, I've already said it came along in 1979. In 1984, there were a bunch of amendments. And in 1984, they added 707B. And 707B said, a court can dismiss a case if allowing the case to proceed would be a substantial abuse of the provisions of the bankruptcy code. All right, not long after that, one sentence too, by the way, two sentences, three sentences maybe. 707B right now is 4 or 5 pages. At that time, it was 2 or 3 sentences. We got a Ninth Circuit case in the late 80s called Kelly, in re Kelly. Very important case and still good law, no doubt about it. The Ninth Circuit, so it's, gospel in the Ninth Circuit. But Kelly's a lawyer. He gets into a fight with somebody, a litigation. He loses. The court enters judgment against him for $20,000. He then paid off all of his other creditors, and he sold his interest in his law firm back to the law firm. He had no equity in his house, or not any over the homestead exemption. Then he filed Chapter 7. And at the Ninth Circuit said, this is abuse. But not for the reason that you think, based on what I just said. It's abuse. The Ninth Circuit says it's abuse because this guy had the ability to pay his debts from his income. All right, that's the Kelly rule, and that is still alive and well. It's been massaged quite a bit. But somebody who can pay some portion of their debts, some meaningful portion of their debts out of their current income, the idea is that person should file Chapter 13 or Chapter 11, pay something. Creditors, and they, every case is bad faith to them. I loaned you that money and you're just trying to walk away. Well, tell Congress, But I've had bankers tell me, well, 10% is better than nothing. Why not at least make them pay something? Why let them just walk away? That's what Kelly said. There's a second big part to Kelly, and that is this concept of what is a consumer debt. Kelly argued that his debts were not primarily consumer debts. The only debts he had, though, was his house mortgage, and this one creditor. And he said that was business, right? So, well, the home mortgage, as with most people who have a home mortgage, the home mortgage is far more than the unsecured debt. So what his argument was, well, by saying that 707B applies only to people whose debts are substantially consumer debt. By saying that, what you're really saying is that people own a house are automatically part of 707B, because that's most people who file, and that's sort of like due process, what's it called, equal protection, Congress can't say, well, look, people who own houses can't file bankruptcy. And the Ninth Circuit said, no, sorry, nice try. The home mortgage is a consumer debt, and that has to be calculated in or factored into whether or not your debts are primarily consumer debts. All right, so let's go then to abuse today. Well, yes, let's go to abuse today. In 2005, the new law came along. There was substantial amendments to the bankruptcy code. A huge part of the world thought bankruptcy was going away, that you weren't going to be able to file anymore, and massive amounts of people filed bankruptcy. By far the most have filed in 2005 than any other year. Anyway, they changed. Why is all that? Because they changed Section 707B. And the basic concept was, this idea of, well, you can't. It's abuse to file Chapter 7 if you can pay some portion of your debts. But what Congress bid on was, these lawyers are representing these people are a bunch of shysters. They're figuring out ways to get around that rule. And these judges, are letting them do it. We have all these liberal judges just letting anybody file bankruptcy, no matter how abusive it is. So they came up with this concept they called the means test. And the means test is designed to compute whether or not you have the ability to pay some portion of your debts out of your current income. We're going to take that out of the hands, Congress says, we're going to take that out of the hands of the bankruptcy lawyers and out of the hands of bankruptcy judges. And we're going to make it so that a high school student can just, get out your calculator and on your phone, get your calculator on your iPhone and, follow this, our system, and you either do or you don't. They said it's presumed or not, but so that's called the means test that I'm going to talk about a little bit. But 707B now says the court can dismiss a case if there is abuse of what? Of the provisions of the bankruptcy code. They took out the word substantial. So now it's just abuse. Section 707B, that's 707B1. Section 707B2 says it's presumed to be abuse if you do all these calculations and there's money left over at the end of the month. And those calculations are just outrageous, I think. There's a form, it's the means test form that you have to fill out now in order to file Chapter 7. There is no chance that I could fill that form out myself without a computer program that, walks you through the numbers. So I'm going to tell you really quickly how the means test work. Before I do that though, Congress helped us a little bit. And they said, well, look, some people, it's sort of silly to fill out this big long form. Who's that somebody? Well, it's people who don't make very much. I mean, obviously they're going to pass the means test. Well, what does not make very much mean? So they came up with this idea that you look at the median income in the state that you're filing in, the median gross income. All right. If your income is below the median income, you automatically pass the means test. You don't even have to fill the form out. If your income is above the median income, then you have to fill the form out and see whether you pass, right? So the median income, you know, median means the halfway point. It means that half of the state makes less than that amount. Half of the state makes more than that amount. All right, so in California, a single person living by themselves, the median income is around $50,000. If you make less than $50,000, you automatically pass. If you're married couple, or you're living in a home with a child, or let me leave it at that for now. If there's two people in the household, then the median income is 70-something thousand. Three people, it's 80 or 90, somewhere in there. Four people, it's 101, I think. You know, the fact that I don't have these numbers in my head is, for one thing, they change every 6 months. And secondly, it's in the computer, you know. I mean, when it really matters, I look it up, but anyway. How do you know whether you have two people or three people? Well, it's people in your household. Congress didn't tell us what a household is. So what about your girlfriend? You know, what about your girlfriend's two kids that live with you, or your parents that live with you? Anyway, I'll leave that to another day. The only reason that's relevant now, at least, is trying to figure out whether you're above or below the median. All right, so if you're above the median, you have to fill out this means test. So we're talking about 707B2, which says if you pass the means test, it's presumed to not be an abuse. If you don't pass the means test, it's presumed to be an abuse. I obviously emphasize presumed because you can go argue with the judge and say, well, you know, that test, and there's some reason why I'm not abusing anybody, you know. Anyway, at least you can argue about it, right? So I'm just going to tell you the basic concept on how you calculate the means test. You start with your income. Well, what does that mean? You know, they don't tell us what income is. What if you sold your car? Is that income? If you took money out of an IRA, that's income. Your mother gives you money each month. You got a loan. You know, you got a bonus 2 months ago. You lost your job, but you're going to start a new job next week. So Congress said, well, income means, remember, they don't want lawyers to have any wiggle room. So income means all income from whatever source, which doesn't really help that much. But it means that came in the last 6 months before you file. So you go back 6 months, whatever that income is, times 2 for the year, divided by 12, that's your monthly income. All right, from that, you deduct numbers off of 3 IRS charts. One chart is living expenses, household expenses. There's a chart for cars, vehicle expenses, and you deduct the amount from the 3 charts. So you take your income, your monthly income, based on the last 6 months, and you subtract these 3 charts. We were all sort of panicked when we saw that. I mean, when they were talking about it before it was passed, because those IRS amounts aren't very high. And, you know, if you're really going to take your income and subtract those IRS amounts, everybody's going to have to file Chapter 13 because there's money left over using that calculation method. And there's, you know, the clients say, what are you talking about? I don't have any money left over. But, you know, Congress started fiddling with it and said, well, what if, you know, what if you have medical expenses? What if you have a child with medical expenses? What if? They came up with roughly 46 what ifs. So it's the 3 charts and 46 other things. Maybe, well, let's see, do I, you know, health insurance. Anyway, I'm getting to the big punchline on the means test, why it doesn't do much other than run up attorney's fees, if you ask me. But the last thing you can deduct on the means test is payments made or to be made on secured debts without qualification. If you have an $8,000 house payment, you deduct that on the means test. If you have 2 cars and your daughter has a car and your mother, you own the car, your mother's driving, and you have jet skis and an RV, you deduct all that secured debt on the means test. That's actually even if you're not making the payments. You know, there's some question about, well, if you don't intend to make the payments, can you deduct the secured debt? But Congress said, you know, you take your income minus these 3 charts, minus all these other odds and ends, minus payments scheduled on your secured debt. They didn't tell us any more about that. So the bottom line on the means test is that almost everybody passes. The only people who don't pass are people who have pretty decent income and no house payment. You know, I have filed for people who have hundreds of thousands of dollars of income, and they have a first, second, third, and fourth on the house, and they're, you know, the $8,000 payment on the first. You know, you walk through the numbers and they pass. In fact, in our office there on the computer program up in the corner, there's a little happy face. While you're inputting the information into the computer program, the happy face will change to a sad face. And that means you're not passing the means test. And a paralegal will walk into my office and say, oh, John, you know, so-and-so, I'm getting the sad face. And sometimes I'll say, well, you know, I'll walk into that person's desk and just sit there and start, well, let's see, you know, what else can we do? I wonder if any of these other things apply that we can squeeze it. Anyway, if you don't pass the means test, it's presumed to be an abuse. Is that the end of it? No, we're pretty close to the end, but Section 707B says, it's got another section. So Section 707B3, which says, even if you don't pass the means test, the court can still dismiss your case as an abuse using the totality of the circumstances. You know, they don't tell us what totality of the circumstances means. You know, what does it mean? I mean, if you have an $8,000 house payment, you know, if you buy a house that's half as big, you'd have $4,000 to pay to your creditors. You know, does that factor into now it's an abuse? And The answer to that is no. There's a case called Jensen it's again in the Central District of California, and Jensen, completely rightfully so, said, if Congress said you can deduct your house payment in order to figure out whether it's a presumed abuse, and that because of the house payment, it's not a presumed abuse, then it can't be totality of the circumstances. Especially since they told us, well, you can deduct all this stuff. They didn't tell judges that you can sort of use your own gut feeling on that, and call it totality of the circumstances. But what's this totality of the circumstances mean? I'll leave it at this. There's a Ninth Circuit case called Price, Henry Price. And it came out right before the 2005 amendments were given to us by Congress, effective October 1st, 2005. And what Price says is, oh yeah, you gotta, it's abuse. We gotta figure substantial abuse at the time. How do you figure out what substantial abuse means? Well, according to Kelly, you look at their income. And what Price said is, well, you also look at a bunch of other things. There might be other reasons why it's an abuse. And I wrote an article, not a law review article, for the California Bankruptcy Journal. And I criticized that case, the Price case, because it says things like, well, did you buy items that are essential or non-essential? Did you file because there's some health problem or loss of wages or some catastrophic events? That factors into whether it's an abuse or not. Did you, the craziest one to me is did you incur debt that you can't repay? Well, that's why they're filing bankruptcy, Anyway, this thing called the totality of the circumstances is still alive. And these things, there are judges today that if you buy a luxury car within a few months of filing bankruptcy, they'll say under the totality of the circumstances, it's an abuse. You're taking some of your income, giving it to Ford Motor Credit so that you can drive this hot car, and now you want to walk away from your debts. That's the totality of the circumstances. All right, so I think I'll close by sort of I could summarize it this way. I get the paralegal comes in, John, there's a possible new client. All right, so hey, how are you? Oh, everything's miserable. I asked them about their property. I want to see whether there's anything that the trustee might want to sell, because they need to know that before they file. But then I asked them about their income, and what I'm trying to figure out is, before that I asked them about their debts. I need to know whether it's primarily consumer debts or not. So I asked them about their income. Well, how much do you make? Well, see, I get overtime. Well, whatever. How much did you make in the last 6 months? And not very much. Well, what does that mean? Is it less than $50,000? Oh, way less. Huh. Now I don't have to worry about 707B. I don't have to worry about the means test because they automatically qualify. What happens though if the debts are business debts? It's a doctor, and the doctor makes $300,000 a year, and has really good money left over at the end of the month. Well, why is he filing bankruptcy? Because somebody sued him, or he, made an investment that turned out to be bad. Somebody sued him for malpractice, that's a business debt. An investment that went bad, that's a business debt. So 707B doesn't apply. So now you don't have to do the means test for this guy. He makes $300,000 a year, and he got into some investments that turned bad. Now he's being sued left and right. What about cause? 707A still applies, but the rule, Kelly, applied to 707B. And this concept of, well, if you can pay some of your debts was brought under 707B. So it's still pretty much, I think, a open area about whether somebody who makes a lot of money and whose debts are primarily business debts has to worry about all this means test. And they definitely don't have to do the means test. But what if they make healthy money? Is it cause to prevent them from getting the discharge? All right, so I'm going to upload this now into the University of West Los Angeles Law School e-learning system. I'm also going to put it on to YouTube. And if you have any comments, by all means, put them on the YouTube comment section. I'll take a look at it, and I'll give you my 10 cents worth. As I said, I'm on my 3rd week, so of the class. There's 15 weeks, so my intention is to do one of these every week after the class. And they can use this to sort of remember what I said. And so there should be the one I'm going to do in the next few days will be on secured creditors. How do you know what a secured creditor is? So thanks for coming. I'm looking forward to your comments. Thanks. Bye-bye.